Okay, so Jen, get started. Tell people about SDEA.
All right, so real quick, I mean, our focus, of course, is going to be on answering your questions today, but we have a lot of people on here, so it's going to be really super quick. We don't want to waste your time on irrelevant things, but we think we should know about SDEA. SDEA is a nonprofit human resources consulting firm. We help employers who are on the employer side of things, dealing with their employer-employee relations, leaves, etc. Our focus strictly, as you guys can imagine, over the last few days has been trying to help our employers maneuver through, going from can I require somebody to use paid sick leave to, unfortunately, the topic of layoffs and cutting hours and things along those lines. So, that's what SDA is here to do. We're a membership organization, and, if somebody has more questions after the webinar, we encourage you to reach out to us or to check out our website.
Okay, so panelists today are the wonderful Christopher Olmsted. He is an attorney with Ogletree Deacons, and if you're members, I'm sure you may have spoken with him or seen him at our employment law update. Jennifer Jacobus, who's our Director of HR Services. You may have seen her on KUSI News yesterday, and she'll be on again on Friday morning just to make her even more nervous.
Yes.
Me, I'm Molly Wood, and I'm an HR consultant at SDEA. So our presentation protocols, first 20 minutes, and we'll buzz through this as quickly as possible because we got the late start. But we're going to go through some FAQs that may answer questions that you already have. Last 40 minutes, we've got our questions and answers, so you can type in your questions, and we're going to leave it on a little bit longer after the spoken part of the webinar is over just to get as many questions as we can, and then we'll kind of group them together, and whatever we didn't respond to during this webinar, we'll get to back to everybody and
share the information.
Yeah. Thank you. And questions will be responded to as they are received, unless it's a question that we think that we already answered. So Q&A, when it gets to that point, the little arrow shows you where you click on the Q&A to do your question and answer.
All right, starting off with, sharing some information. I know that what we're dealing with right now is out of the norm. It's uncharted territory. As Molly and I were talking to Chris earlier, that we are literally having to deal with this changes on a day-by-day and sometimes even an hour-to-hour basis. The word of the day that I've been using, or for the past few days, is fluid. We're in a very fluid situation. But if we take a step back, a lot of the things we're dealing with are, as the slide says, not unprecedented. We've had to deal with similar situations as far as other disasters, some of the wildfires and things that Molly's going to talk about in just a second here. So we do have some, past experience, and probably, meaning you guys, do have past experience on how to deal with these situations.
So just examples like natural disasters, and again, this is different because it's nationwide. It's not isolated to a specific area, but changes in business environments. So, if you have acquisitions, sometimes you need to do layoffs and mass layoffs. You've got market factors, recession, so the 2008 Great Recession. I think with the recession, we had a little time to plan, but with natural disasters, not as much. And then now we've got COVID-19, which is, again, it's unprecedented, but everything behind it isn't necessarily.
Terms that we are not used to. I mean, so familiar with COVID-19 and something that none of us had heard of, probably a few months ago. And what else? Oh, social distancing. I was saying that's something, a term I've never ever heard or used before, and now it's, of the norm. But setting that aside, some of the simple things, or maybe more simple, I guess, policy considerations when we're looking at employees that need to take time off, that are required to take time off, whether they're sick, their kids are home, et cetera, looking at some of the different policies that are already, again, questions that are answered in your handbooks, hopefully. Sick leave, based on whether you are in the city of San Diego or the state of California, that, you've got mandatory sick leave that you have to offer to your employees. that they're definitely eligible to use that time for certainly their own illnesses as well as caring for a ill family member. I'm guessing some things that Chris will probably will defer to him is some of the legislation in the bill that has been proposed, that has been approved by the House, but we're waiting for the Senate on this mandatory paid sick leave, this 2 weeks of sick leave that, unless, Chris, you can chime in, but I don't think we've heard any finality on what's happening with that as of this webinar.
That's right, Jennifer. The bill has passed the House and is in the hands of the Senate and has yet to be passed there or signed by the President. It's changed. It's had several iterations while it's in the House, and I imagine it'll be redrafted again in some respect as negotiations continue. So we can't really say exactly where this is going to land at this point in time. It does seem to have a component in it for some amount of paid sick leave, as well as extended protections for basically FMLA-like leaves for people affected by the illness, who either have the illness or have a family member who has the illness. And so it'll be a number of days, at least probably not expected to pass this week. And then once it does pass, there's expected to be at least a 15-day implementation period. So stay tuned. We don't have the final answer yet on that one.
All right, okay, so kind of confirming that.
Yeah, and with sick leave, just realizing, at least here in San Diego, that to get medical certification from your employees may not be possible.
Right.
So, you know, if somebody has flu-like symptoms, pretty much all the urgent cares, hospitals, such, are saying, unless you've got shortness of breath, you know, just stay home, take care of yourself.
Yeah.
Sorry, we can't be bothered with providing you with a doctor's note.
And I think a big thing, which kind of alludes to the next bullet point on here, you know, employers considering suspending their attendance policies. And I know everybody has a business to run, and, you know, we've got that concern as well as the concern of our employees. But as much of it's possible, you know, we're really encouraging employers to be flexible. Certainly with attendance policies requiring doctor's notes, it's not going to happen. You know, I got a note from my doctor actively saying, we're not taking anything that's non-essential. So, you know, those policies that say if you miss 3 or more days, you have to bring in a doctor's note, that's just, you know, and also thinking about just the infrastructure of bombarding these doctors with maybe things that might be a little bit unnecessary. PTO vacation policies, you know, considering where you can and cannot require an employee to use the time, what your policies say. You know, if somebody's out, if they've exhausted all their sick time, for example, again, we're suggesting, if you can, to be flexible on allowing employees to use vacation, even though it's for an illness. What's that bullet, Molly?
And if you are requiring people to use their PTO, then, you know, maybe you're going to allow for unpaid absences later in the year, because this is, no, people don't have control over this, and they're using up all of their PTOs. So just having some flexibility with that is a nice thing.
Yeah. Other things to consider, of course, telecommuting is a big thing. We don't know, and I'm not trying to say I have any inside information, but there's a good likelihood where we're going to be shelter in place, just like they're doing in Northern California, and I think maybe Orange County or something. You know, and being proactive in considering what your telecommuting policies are, what the requirements are going to be. You have to be, for your non-exempt employees, you know, that they're still taking their meal and rest periods, that they're recording their hours, probably putting some restrictions on work times, addressing overtime issues. And because telecommuting, in many cases, is going to require employees use their own computer, cell phone, et cetera, that there's going to be some requirements for reimbursement. You know, the state does not allow employers to hold their employees accountable for the cost of doing business. So if employees are required to use their own, you know, internet, cell phones, et cetera, there's going to be some costs associated with that. And last we have on here, I'll pay for exempt versus non-exempt employees. General rule here, and I don't think anything has changed. Of course, Chris, you know, you can always jump in here, but non-exempt employees, they're paid for all hours worked. So if they're not working, generally you do not have to pay them. There may be some reporting time pay owed if we're sending a non-exempt employee home working less than half of their shift. Exempt employees need to be paid unless they're absent for a full week, unless it's for personal reasons or sick. So did you want to add anything to that, Chris?
Jennifer, I think you've got it right. I think there's a helpful publication online with the California Labor Agency called the DLSE, and they have a FAQ page that covers some of these issues. And what they've indicated is that California law is consistent with federal law with respect to paying salaried employees. If they've worked at all during the week, they get their weekly salary, but then there's exceptions if they take time off for personal reasons or they're using accrued PTO or sick pay. Does that make sense?
Yes, it makes sense to me.
Okay.
We'll take some questions on that, I'm sure.
Yes. And job protected leave consideration. So the first bullet is just talking about the bill that is still pending. So there's a possibility that FMLA may be expanded. But if you fall under FMLA or CFRA, and somebody is sick, then, you know, they maybe have a job protected leave. There is talk of expanding it for quarantine, but again, that's not a done deal yet. So the FMLA CFRA is basically just speaking to what is potentially in that bill. Also realizing that there may be job protected leave due to disability if somebody is sick. And Chris, do you want to add anything to the job protected leave thoughts?
Yeah, so I think that looking at what that federal bill says will be important. Generally speaking, the COVID illness may not be considered to be an ADA disability. Generally speaking, temporary transitory illnesses such as flu or colds or other type illnesses have not been considered disabilities. Certainly that could be different for people that have pre-existing health conditions or autoimmune deficiencies, respiratory issues that are impacted by this virus, or severe illnesses which require hospitalization. But just having a case of COVID-19 in and of itself may not rise to the level of a disability requiring accommodation. Some of these leave laws like FMLA and staying home to care for children and sick pay, et cetera, those will apply here, but the ADA may not ultimately. It's going to be dependent on the circumstances of the individuals. But I would say for the most part, it may not be a consideration when it comes to granting time off.
Okay. And then reduction in force considerations. So for our purposes, the term furlough and layoff have been interchangeable in some of the research that we've done, but just for our purposes so that we kind of are speaking the same language, we're looking at furloughs as no scheduled work, but the employee is not terminated. So they're still on the books, but you just don't have any work for them. Layoffs being the employee is terminated. You want to have a non-discriminatory methodology for who's selected. So could be seniority, last in, first out. If you've got employees with performance issues and you want to choose them first, make sure that those are documented because you don't want it to in any way look discriminatory. You can look at cross-training. So if you have an employee who's cross-trained to do 3 different jobs and 2 other people who can only do 1 job, that could be a methodology. So you just really want to look at, how are you making these determinations of who's going to be impacted. Reduction in hours considerations, and we have been really digging into the whole work share program through the EDD. And Chris, if you have any more insight into this, please let us know. As far as I could see, it looks like Workshare provides for maybe less paperwork. Chris, do you know more about this? I'll let you just start talking rather than me shooting off.
Sure. Well, first of all, if you go to the EDD's website or just do an internet search for EDD COVID-19, you're going to come across their website that has particular focus on the current circumstances. Among the other links they have on that page, you'll see that they have reference to their Workshare program, which essentially means if you have to partially reduce the hours or work of an employee and they're only earning a portion of their regular wages or salary with you, they may have an opportunity to apply, or you may have an opportunity as a company to apply with the EDD for a program where, despite the fact that they're employed, they will get some measure of EDD benefits. And the amount that they receive would depend in part on what their take-home wages are compared to what the EDD's unemployment benefits would be if they're unemployed. So in other words, if you take, let's say their EDD benefits would be $400 a week, they're now only earning $200 a week, it might be possible, and again, this is just an example, I'm not quoting from their regulations, but they may be eligible for up to $200 a week in my example of EDD benefits. So if you're considering a partial reduction in the workforce or reduction in hours, then the resources that the EDD has available may be pertinent to your workplace.
And with the research that we did, so with Workshare, you are required to continue medical benefits at either the same medical and 401k. You need to keep those programs in the same level that they were when the person went out on Workshare, or if you're reducing benefits for your entire organization, even the people who aren't impacted with the Workshare and getting reduced hours, then you can reduce their benefits. So that is a requirement. Again, in kind of digging into it, it looks like Workshare maybe has less paperwork than having all of your individual employees just go to the EDD site because they've had a reduction in hours. And you do want to think about the impacts to benefits eligibility. So if there's a reduction in hours, are they still going to be eligible for your benefits, or is that going to be a COBRA qualifying incident? Exempt employees, we've had a few members who have called in saying, okay, well, you know, I have an exempt employee, so I'm going to reduce their hours. So, you know, what can I do about their pay? Well, you can reduce a salary of an exempt employee. They're still not being paid by the hours they're putting in. They're being paid by the work that they do, but you know, technically, presumably are expecting them to do less work because you're expecting them to be there less. But you still do have the minimum salary requirement of 2 times the minimum wage, so it can't go below that. And if it would go below that, then our recommendation is you just make the person hourly for the time being. So
you know, hopefully sooner rather than later, we'll be talking about what, you know, we need to do to kind of get back to what our new normal is going to look like. This is definitely an area where SDEA can help. I don't want to spend a ton of time on this because I know you guys have a lot of questions, but just like any other situation, communication is very important. And I think even communicating with your employees during this time, if they're not working, you know, they've been furloughed, reduced hours, put on hopefully what is a temporary layoff. Everybody's nervous and anxious and unsure about what's going on. So I think it's important to communicate with employees and, you know, without making promises, of course, or anything along that's going to put you in a situation, but, you know, reaching out to them when you can. Considering what your return to work plans are going to look like, you know, how is the onboarding process going to be? Are you going to be able to bring everybody back? Are people going to be coming back sporadically, you know, and what's that going to look like? How are you going to make that determination of who returns first? Probably critical positions, people with experience along those lines. Benefits reinstatements, you know, employees getting back into their health benefits if they were COBRA'd, you know, their accrual, vacation, you know, what that's going to look like. There is help, and we are certainly not experts on any of this information, but we're going to have a link on our website to the San Diego Workforce Partnership, which assists with layoffs and does have more information on their site about loans. But the San Diego County small businesses are eligible for disaster loans, and Molly has put a link up there for that. Of course, again, like I said earlier, that, you know, we're here to assist our members with planning, you know, not just for all the crummy stuff we're going through now, but hopefully on the happy side of helping you guys get your workforce back to normal.
All right, so now we're going to go through our questions and answers. We've got some that have come in already, and then going to that Q&A, you can type some in. So, first question we've got, if we want to allow 65-plus-year-old otherwise vulnerable employees to work, what about having them sign an acknowledgement that their employer advised them that they could stay home and they chose to continue to work despite being at greater risk to contract COVID-19? What exactly are the WARN Act emergency exemptions to notice requirements? Chris, do you have thoughts on that?
I do. First of all, it's actually two questions, and the first has to do with the 65 or older issue, and then the second one has to do with the WARN reduction in force rules. So first of all, with respect to people 65 or older, first of all, just to catch everyone up, health agencies have noted that those that are 65 or older are particularly vulnerable to this virus. It seems to be impacting the older more than the younger. Some of the stay-at-home orders that we're seeing across the state and across the country are focusing on older people, 65 or older, in some cases 70 or older, depends on the agency. So this will become an issue in the workplace, and I think it is important to communicate with employees who fall into that category and let them know that they have the option of staying at home for their own personal well-being and health. I don't think that some sort of release or waiver is really the right approach here. I think more just giving them information and letting them know they have an option or a choice is the better approach. Does that make sense, Molly?
Yes, that makes sense to me, so hopefully that works.
With respect to the WARN issue, this has been sort of an ongoing issue of discussion, as you might imagine, amongst attorneys. And particularly, let's focus on the California WARN Act. There's a federal WARN Act that applies to larger businesses and involves mass layoffs. But the focus here in California has been the California rule. I think the latest word is that the California Governor, Gavin Newsom, issued an executive order last night stating that employers are relieved of the obligation to give 60 days full notice before a mass layoff or shutdown, which is very helpful. Generally speaking, in California, if you've got a business location with 75 or more employees and you lay off 50 or more of them within a 30-day period, or if you close down the facility, then the obligation is to give 60 days advance notice to the employees that this is going to happen. And the penalty for not doing so is you may owe the employees for any shortfall in the notice. If you give them 10 days notice, you still owe them 50 days of pay. Plus, there's a daily penalty of $500. So this has been a concern to employers across the state who are confronted with circumstances where they may need to rapidly lay off people for a variety of reasons and potentially shut down locations. What the governor has said is that the 60-day notice in his executive order, he says you're relieved of the obligation to give a full 60 days notice because obviously under these circumstances, things are moving too quickly to give that sort of notice. But notice still needs to be given as soon as practically possible. So if you are going to encounter a mass layoff of 50 or more employees, or you're going to have to shut down your facility, then you should be giving written notice to your employees. Our firm's developing form notices that we're helping our clients with under these circumstances. In addition to the notice that goes to the employee as soon as possible in the case of a mass layoff or shutdown, notices need to go to the state EDD, the local workforce agency, and the local city and county representatives. Typically, there's just one letter that's addressed to the different organizations. So in the event that you are looking at a mass layoff, I'm not talking about laying off 1 or 2 people, but a mass layoff of 50 or more employees or shutting down your facility that has 75 or more employees at it, you're going to need to do some planning and get in touch with your legal counsel as far as the types of notices that you need to provide. But again, the bottom line is you're relieved. If you follow these other requirements, you're relieved of the obligation to give a full 60 days of notice. All right, what other questions do we have?
Okay, we've got a real quick, easy one. Will you be sending us all the pages after the seminar? We will be posting this webinar onto our website, so you can access it there.
Which one am I reading? Okay, so here's one. What language would we advise to use in job offer letters regarding possible delayed start dates for factors beyond our control related to COVID-19? What is our potential liability if someone has already given notice to their previous employer?
So I'll just jump in terms of language. If this is an offer letter that's coming and you don't know what their start date is going to be, then you can certainly put language in that, just stating your start date will be determined. It sounds like if you're saying potential liability, if someone has already given their notice, it sounds like it already went out there, so you would want to communicate to the person why their start date is getting pushed out. And Chris, do you see any potential liability as far as someone having given their notice?
We're back to the word fluid circumstances here. I think under the present circumstances, things can change rapidly. I think that if there is a concern about the start date, then the thing is to communicate immediately any reservations or retractions of the job offer. There potentially could be a problem if someone were to misrepresent. We're going to hire you, let's say April 1st, but we don't really mean it. Inducing someone to quit their job and then finding out that there is no job to come to. On the other hand, if unforeseen circumstances, either because of a government order or because of dire financial circumstances, cause an employer to have to either retract a job offer or even shut down the facility so that no one's working, then I don't think this is going to be a situation where there's going to be liability to the employer. But again, to reiterate, the bottom line is please immediately communicate any reservations or any retractions of offer letters so that we don't have to unnecessarily deal with situations where the person was induced to quit their job only to find out that there is no new job after all.
Okay, here's, Chris, I don't know if you, because due to the bill that has not passed yet, so this is another what if question, and so I don't know if you know the answer to this, but if the sick leave does get extended to another 80 hours, hypothetically, or 2 more weeks, and an employee has already used 40 hours, do they get an additional 80 hours on top of what they've already used or what has already been coming to them?
Yeah, unfortunately, I don't know. I did just get an email from one of my Ogletree colleagues during this webinar that I accidentally looked at because I know I'm supposed to be paying attention to the webinar.
Okay.
But it says that the bill just passed in the Senate and it's on its way to President Trump. So we do have a final version of the bill, but I haven't read it yet. So the bottom line answer is I don't know, but we'll find out.
Okay. All right. Okay.
And then we have a question about basically furloughing people who are in at risk, so specifically people who are over 65, people who are pregnant. If they are not able to telecommute and you're not allowing them to come to work, what is the implication there? Could it be considered to be discriminatory? Can you not allow people who are at risk to come to work even though they're not sick?
Yeah, I would refrain from exercising judgment on who is healthy enough to work. That can get us into all sorts of trouble. Rely on the individual's own judgment and discretion and the doctor's recommendations rather than deciding who can't work. Again, going back to the original question, I think it's important to communicate with employees and let them know that in the event that they are encountering health conditions that require them to be away from work, that you as the employer can accommodate them if they engage in that discussion with you. But please don't tell people, please go home because you're pregnant or over 65 and therefore shouldn't be working.
So that kind of leads us to a very common question we get about sending employees home. And I think from what I'm hearing from you, Chris, and probably some of the advice that Molly and I have been giving, that, I mean, I think there has to be some blatant signs that somebody, you know, they're sweating profusely or coughing or something. And where do you make the call to say, to make that determination where you're kind of playing doctor to say, you know what, you need to go home?
So fortunately, the Centers for Disease Control and Prevention, the CDC, the federal agency, has issued guidance on this topic. And I think the safest thing for employers to do is follow that guidance. It's hard to criticize a company for following what the government is saying it should be done. So they say that employees that are exhibiting symptoms of acute respiratory illness and fever, they say specifically greater than 100.4 degrees Fahrenheit, so that would be coughing or fever basically, or have, you know, been in close contact to someone who has those symptoms as well, can be sent home, either voluntarily or involuntarily. The CDC's guidance says so. So I would refrain from generally just saying if you have any sign of any illness, you must go home. I think we need to look closely at what the CDC's guidelines are, and they're referring to specific types of symptoms that could indicate that someone has the virus.
Okay. And this would trigger potential reporting time pay for non-exempt employees?
Not necessarily. If they're not fit to work, then they may not be owed reporting time pay.
Perfect.
However, if you call them into work, they're expecting to work a shift, and then you say, well, we're going to close down today because we don't have any customers, then you may owe them their reporting time pay, which would be up to half of their scheduled shift, minimum of 2 hours, maximum of 4.
All right, and we have another question. California is a strict privacy state. How vulnerable are we to ask they may have or been exposed to COVID-19 and urge them to get tested? And I actually just saw on the EEOC website, it was just updated today, that the EEOC is now saying that it is okay to ask employees if they've been exposed and ask them if they have the symptoms. Chris, do you know if that would usurp any privacy in California, or in California, are we still hesitant to do that?
I think with specifically with issues related to COVID-19, the guidance is that you're allowed to ask questions about any symptoms or exposure to it. That does not give you license to ask about any other medical conditions, because I think that would be an invasion of medical privacy. But on the topic of COVID-19 related symptoms, there is an overriding exception with respect to the health and safety of the workplace. And so that's why you want to focus your inquiry only on COVID-19 and not generally someone's overall health.
Okay.
The specific language, for example, in the ADA is that the employer can act where the condition is serious enough to pose a direct threat to the employee or coworkers, and clearly questions designed to determine whether the person has been exposed to the virus are designed to prevent a direct threat to the workforce.
Well, and that brings up a question that I had earlier today about an employee that was returning, I believe, from the Philippines, which is not, I think, level 3 or code 3 or whatever the proper term is. And the coworkers are concerned, to have this person come back to work, which they're ready to return, what can employers do about that? Like if employees, can they require they stay home if there isn't any really blatant risk or signs of illness? They've been in potentially, they have been in an airport, or if they have, we don't know where they had to change airplanes and all that kind of stuff. What are the employers' rights for that?
Yeah, so even if an employee is asymptomatic, in other words, there's no observable indication that they have the virus, the government agencies that we're dealing with have made it clear that as a sort of a preemptive approach, companies can send home employees if they fit within certain categories established, again, by the CDC's guidance. So as a homework assignment, I think it is important to do a little research and start reading up on what these guidances are. And we don't have time to read through it in great detail. But for example, if they have been in close contact with or been within 6 feet of or sat on an aircraft nearby to someone or lives in the same household as someone who has been exposed, then even though the employee's asymptomatic, it might be okay to send them home. I would refrain from just merely sending someone home because they happen to sneeze or cough in the workplace. I think that's probably above and beyond, but I think looking to the specific CDC guidances, if they're asymptomatic, they can still be sent home under certain circumstances.
All right, and we have a question. Okay, if you have an exempt employee that you would reduce their work and pay by 20%, and they would fall below the minimum salary requirement, but we allow them to use their vacation time to make their salary 100%, is that sufficient for maintaining their exempt status? Or would you recommend transitioning them to non-exempt for now in advance of them potentially running out of vacation pay? And I'm giving that to you, Chris.
Okay. It depends on your PTO policy, but essentially what you're doing is you're allowing someone to draw down on their PTO. But the question is, you're saying we're forcing you to do that. We're deducting your pay, and then we're saying to make up for it, you can use your PTO time because we're requiring you to work less hours. I have a concern about taking that approach, and I would caution employers against doing that. I think the risk is that we're going to lose the exemption, and so I think the better approach would be, first of all, allow people to use their PTO or sick pay as consistent with your policies. Number two, if you're going to reduce an exempt employee's salary, don't do it below the current state minimum amount for exempt classification. And number three, if you have to, because of business needs, reduce someone's pay below that minimum salary level, then convert them to non-exempt status and pay them on an hourly basis.
Okay. And question, which is just kind of asking clarification about exempt employees. I thought you could deduct exempt employees for full days off if you have a sick pay policy. So yes, that is correct. If you have a bona fide sick leave or PTO policy, so an employee can use that if they're out sick, and if they exhaust that and they're out sick for a full day, then you can deduct their pay for that full day. And Chris, do you think I said that appropriately? Jen, do you think I said that appropriately?
I agree. Yes.
Okay.
I think that was appropriate.
Okay. Was it clear?
Yeah.
Sometimes when I'm explaining those things, I'm like, okay, am I being clear? Can employees file for unemployment if the employer is not part of the work share program? My understanding is yes, you've got a reduction in hours. It's just that the paperwork's going to be different, and what the EDD asks of you is going to be different.
At what point does an employer go from a furlough to a layoff? Is there a time frame? I'm not aware of any specific time frame. Maybe you are, Chris, but I think a furlough indicates that the person is returning in a some significant short period of time that there is work projected, that, you know, I think some of our members that we're dealing with might be like, let's say a catering company or something like that, where they're, you know, are called in for work as needed and there just isn't anything on the books right now, so they're kind of furloughed. Is there a better way to explain that, Chris, or is that, I feel like the words are used interchangeably a lot.
Yeah, the two terms don't necessarily have any meaning within the law itself. I agree with what you're characterizing it as, that being a furlough is a temporary cessation of work, but with the intent to call someone back at a point in time, whereas a layoff is a separation of employment with no specific intention to recall them in the future. Either way, it is an end of employment relationship, and so it could entitle someone to apply for unemployment, and I think it's all in the messaging as far as trying to retain a workforce for when the company gears back up. I would encourage employers to issue final paychecks in the event that you're not going to be recalling the employee within the current pay period. So if someone's going to be let go now, and the expectation is they won't be returned before the next pay period, then I would go ahead and give them their final pay today.
All righty.
Okay, that's really good to know. We usually utilize Facebook portal for meetings. Can we require employees to take them home to use? And I'm not sure I completely understand that answer, but it kind of sounds like, can we make employees take telecommunication devices home? And I think that kind of just goes to the telecommuting, that yes, you can require, you know, in these times you can require that your employees telecommute. Clearly you need to be paying them for any timed work. And again, what Jennifer was saying earlier in the FAQ part, if they're hourly employees, then they need to understand that they still need to clock in, clock out, take their rest and meal periods. And you probably would want to put some guidelines around, you know, when non-exempt employees are working.
Do exempt employees need to be paid during the shutdown? I think we addressed this a little bit earlier, that if an exempt employee is not doing any work during a full work week, they do not need to be compensated. So I think our recommendation here is, if you expect that you're going to need an exempt employee, maybe to check in messages, because even checking things like your email or calling in to check messages, maybe somebody has to drop by the office and do a bank deposit, you know, those are going to be things that trigger work. So if you believe the employee is going to be very limited, I think our recommendation here is to convert the exempt employee to a non-exempt position during this period and pay them for hours worked only, which could include overtime, of course.
And if we eliminate hours for a few employees until we reopen the office, do we have to sign up for the work share program? Or can we keep these folks employed and encourage them to file with EDD in the interim while they're not working hours? Yeah, that's a situation where I would just say that, you know, they can go to the EDD and say that their hours have been reduced to 0, even though they're not terminated. You will get something from the EDD that says, you know, does this person continue to have reduced hours? So it's just a little bit more paperwork maybe than the work share. But if you look at the work share application, it's pretty hefty too. So if you've just got a couple people, then that's probably going to be the easiest route to go.
What would we consider to be reasonable reimbursement for internet, phone, et cetera, and suggestions on how to determine? One of the resources that we're going to be putting up, I mentioned that we're going to have a checklist and a sample policy for telecommuting, and Molly shared with me today that she put an Excel sheet together to help employers make that determination. So we're going to be posting that on our website. We're hoping to get that information up before the end of the day.
Yeah, and basically, though, something to be aware of is that when you're reimbursing employees for their internet or for their personal cell phone, you know, it's not your problem if that person's personal cell phone, if they've got their mother and their brother and their 8 children on their cell phone plan, and therefore their cell phone plan is $500. You'll be looking at what's the average cost of an individual person's cell phone plan. you know, what's the average cost of an internet plan? And I'm going with $45 because that's what Spectrum keeps advertising. And if you're consistent on those with all of your employees, then, you know, that should be a reasonable reimbursement. And Chris, do you agree with that?
It's a tough question to answer, Molly, from a legal standpoint. The bottom line is we need to come up with some methodology for reimbursing for people for using their own devices. The law hasn't defined what the reimbursement is, so we have to come up with a methodology. The suggestions you're making are appropriate for consideration, but I can't just sit here and say that's going to work for all workplaces in all circumstances. So sorry to give that little caveat. It sounds very lawyer-like, but I just can't, you know, make a blanket statement regarding reimbursements. And
I always say accounting is black and white, HR is all shades of gray. So.
Right, yes. Let's see, we've got from what I've heard, we can reduce the salary of an exempt employee during this time if there is less work available, or switch to hourly non-exempt. So you need to be careful when you are associating hours and salary with your exempt employees. Again, our recommendation here is at SDA that you do kind of a percentage across the board. You may be reducing the hours of your non-exempt hourly employees, but you're probably going to be safer to have a percentage cut, like 10% or 20% across the board that applies to your exempt employees. You still have to be careful because you can't prorate their salary, so you have to make sure that they're still at the mandatory state requirement, you know, depending on the size of your company, because it's 2 times current minimum wage, depending on the size of your company. So it's either, well,
it ends at the 13 is 54,080, and the 12 is like 49, and I don't remember the last 3 numbers.
So we can get more information for you on that. But if you think that that's going to bring those exempt employees below that salary standard, or again, as I referenced a minute ago, that they're not going to be really working enough hours to justify that, then you may consider, again, converting them to an hourly non-exempt employee during this period, which again, you know, it means overtime. They have to track their hours. There's going to be meal and rest period requirements associated with that as well.
And is there workers' comp exposure if employees contract COVID-19 at the workplace? I've seen this mentioned elsewhere, but it's not typical for viral illnesses. And Chris,
we're giving you all the hard questions, Chris.
I know. I mean, my thought on this would be they can file, and it's up to your workers' comp carrier to see if they want to fight it or not. But
yeah, I would say that would be hard. But what do you think, Chris?
Typically, exposure to viruses do not lead to valid workers' compensation claims for a variety of reasons, which I don't think we should get into in this call. There are certain exceptions relating to biological exposures out of healthcare type organizations, which has limited application. So let's just leave it at that.
Okay. All righty.
Okay. For unemployment, does it matter if it's labeled as furlough versus layoff? Once you go and apply for unemployment, they ask, you know, it doesn't matter in the box. You can say kind of whatever it is.
Yeah.
Then they're going to ask and say, what was your last day worked and how many hours did you work and all of that. So I guess basically it doesn't matter, furlough versus layoff. They're going to try to find out what happened, and it doesn't really matter what word that you use.
Are there restrictions on terminating employees that have been laid off previously? Example, an individual with documented disciplinary actions is laid off due to corona. Can they be terminated during layoff or soon after returning? Okay, so I'll give you my opinion and you jump in here, Chris, but I actually think documented performance issues are going to be more beneficial during a layoff. You know, when we're having layoffs, there should be a method to who's being chosen. I kind of always use the example of today we're here, maybe from a dollars and cents standpoint, and you know, by end of week we need to be here, going from point A to point B, and documenting your processes of how you're doing that. Who's getting chosen for layoff, and people that, you know, are in protected categories, we may have to look twice to make sure, for example, if we lay everybody out and go through who is going to be on our layoff list, and if there's a majority of those individuals in a protected category, you know, based on age or race, you know, that could raise some red flags. During this process, I think employers really want to keep their best employees around naturally. You know, if they can do more than one job, they have better skills, better attendance, whatever it is. But having that information documented, if you are making layoff decisions based on performance, yes, make sure you have it documented, but I think that's actually going to be more beneficial in helping make those decisions.
So, and Chris, did you want to add anything to that?
No, I think Jennifer covered it.
Okay. All right. So I'm getting many employees that have reduced hours asking us to fill out the DE 2063 form from the EDD. Is this something that I can fill out at the beginning of the same week they have the reduced hours, i.e. their reduced hours start Monday 3/16, they want to start their EDD paperwork the same day? Well, if you're speaking to the previous week, then yes, you can fill it out because you know. If they're asking you to fill it out for the upcoming week, you wouldn't know. This is kind of an example of where doing a work share may end up being less administratively cumbersome because you wouldn't, my understanding, and it's not totally clear on the EDD website, so disclaimer there, but I think that you wouldn't have to fill out this DE 2063 for all of your employees if you did do a work share program. And you do want to fill it out as soon as possible because my understanding is that the EDD will not pay the benefits until they get the information from the employer. So
yeah, because the work share program is for a specified period of time. So it should, again, our understanding is that it should cover that period of time that the employer has applied to be in the work share program.
Although when I looked at the application, I didn't see start date or end date on it. I might have just overlooked it because it's a pretty hefty application, but
if you allow employees to work remotely, can you require them to work standard work day from 8 to 5 with a 1-hour lunch? Absolutely. And I think setting standards and when the workday starts and ends, that they're taking their meal periods and their breaks, is going to be more beneficial to the employer. So yes, you can still have your standard workday. It doesn't mean necessarily that employees get to work, you know, in the middle of the night, especially if they need to communicate with other staff or customers or clients, you know, during what would otherwise be normal business hours. But I think we're recommending that you would actually apply that and require that of your employees. Can we specify hours of work for employees who are telecommuting? So same thing. Maximum response times, yes. And it's really critical to set those standards up. You're going to get, you know, employees, we don't want them to think they're on vacation while they're working from home. So setting those parameters up ahead of time as they're, you know, walking out the door with their laptop, so they know what the requirements are, what the hours are, what the expectations are. You know, we expect you to get back to us within a reasonable period of time that you can set. Yes, definitely yes, yes to all those.
And the IRS provides for disaster leave donation programs. Does California have any requirements for this type of plan? That's kind of a tax question, and I have no idea. Chris, do you have an idea on that?
Yes, so the question is addressing the concept of we all have accruals of PTO or sick pay, and if we want to donate some of our accruals because we don't need it, but we want to donate to someone else, can we do that? The IRS deals with a complicated issue of, well, so you've accrued PTO, you've accrued vacation, it's wages. And if we're transferring it from one person to the other, what's the tax implications there? So that gets complicated. But the IRS has made a publication available that outlines the criteria for a donation program. And so if anyone's interested in setting up one of those programs, I think it's important to carefully follow those regulations. You might want to get help from your attorney on that. To my knowledge, there is nothing specific at the California level that modifies the IRS criteria concerning the donation program. But again, it's something that you can't just flip a switch on. You need to design a particular program and have a written policy that you're going to follow in that instance.
Okay.
Yeah, and want to let everybody know we are going to be wrapping up in about 3 minutes here, but I am going to leave the webinar open for 15 minutes after that, so you can continue to type questions in. So if we have not gotten to your question, we'll be running a report on those. Like I said, we'll be sorting them together because there are, some people have asked questions that were addressed already, and we'll send that out to all of the participants.
Yeah, so we have time for a few more. Should employees file now with the EDD if it takes 2 weeks to qualify to receive payments? I don't think your employees can file until they're actually laid off. So I don't think they can file with a projection of a layoff or thinking they may get laid off. Yes, there is probably, and there may be more of a delay. We don't, the EDD, I know we've read that they're bringing on an extra staff and trying to, handle this the best they can, but they are obviously going to be completely overwhelmed with all these claims. And this brings up another point, which you guys probably know, but the EDD has waived the waiting period for both unemployment benefits and disability. So there's a 1 week waiting period, 7 days, that has been waived. So your employees will be eligible for benefits starting from the first day of layoff.
Okay, for those of us still operating, should we be documenting what we're doing to protect employees? Extra cleaning, creating space so employees are distanced, et cetera. Reason, are we liable if an employee says they contracted the virus at work?
That might be a feel good for your employees. I think from an employment law, even though Molly and I are not attorneys, but from an employment law standpoint, I don't know that that's necessary. Maybe make your employees feel better to communicate that with them, though. What else do we have on here? Yes, we're sending the PowerPoint, working remotely. Some of these are duplicates, so we're trying to find something else that would be applicable to all you.
Okay. If we come to layoffs, skill-based, yeah, we already spoke to that.
Here's a WARN notice, Chris, I don't know. WARN notice, 12 employees in a location. Can I assume WARN doesn't apply? Oh yeah, never mind. It does not apply. You have to have 75 employees.
Is the temporary shutdown of operations the same notice as permanent shutdown of facility?
For WARN Act? Well, I think Chris addressed that they're waiving that requirement, so hopefully that is a moot point.
If an employee has already exhausted their sick vacation accruals, is an employer obligated to pay sick vacation that has not yet been earned by the employee? No. But if you have, like in your handbook, if you say that an employee can go X number of hours into the negative, you just want to be consistent with your policies.
And Chris, can you address real quickly, is there a difference for an employer being able to require their employees to use sick leave, vacation, PTO based on the reason that they're missing work?
Yes, so the California Labor Agency has taken the position that you cannot require people to use accrued sick pay. It's their choice to use it or to be unpaid. Okay. So when it comes down to sickness, you should refrain from requiring it, but you should allow them to use it, if that makes sense.
Yes. And then the vacation and PTO would be for reasons obviously other than sickness. But what if an employee is, let's say they voluntarily want to stay home, they think they're at risk, or they have a family member. We've been getting those questions. I live with my grandparents or something, and I don't want to bring something home for them, and the employer says, all right, well, you can stay home. In that case, can an employer require an employee to use their PTO or vacation?
Yeah, the rules are different for vacation and PTO, and you should just follow the terms of your own written policy in that case.
Okay, all righty.
Okay. All right, so again, we apologize for the late start, and thank you everybody for your patience and diligence in getting through. Chris, we know you have been completely inundated, so again, thank you so, so much.
Thanks for your time.
For your time today and the extra 15
My pleasure
minutes.
to help everyone out. Thank you.
Yeah.
Thank you. All
right.
I am going to leave the meeting open